Hello, everyone. Welcome back, guys. I can see few people again with me. How are you all doing? How is the preparation going? Let's begin with the quiz. Today, we are going to take Indian Evidence Act. Are we on the? Am I audible? Am I visible? Please start commenting on the chat box, all five of you. All six of you, good evening, Prishita. How are you? Good evening, Medha. Good evening, Prachi. Good to see you. Yes, audible and visible. Okay. Good evening, Ankesh. Finally, you are here with us on the quizzes now. Okay, finally it worked. It wasn't working. I don't know why. There was some technical issue. I had to restart my computer. I think we have a good amount of people today, and I can see some new names also. Hi Aditya, hi Shubham, hi Divya, hi Shubham, hi Divya. So let's begin with the exact today. I think everyone here know the rules. I'm going to give you 5 seconds. The question will be displayed on your screen, and you'll have to answer the question. Okay. There are generally 5 stages in any civil or criminal case. At which stage is evidence presented? First stage, second stage, third stage, or fourth stage? Come on, everyone. Waiting for the answers. Okay, if the voice is breaking, Prachi, please read the question and then try to answer. Stage. Yes. Can somebody tell me in the chat box what all 5 stages are there in a criminal proceeding? Yes, it is the third stage. The evidence is taken at the third stage. In a criminal case, evidence is given by prosecution, complainant, accused, all of the above. Come on. Everyone was right. Shubham was right. Priyanka was right. Pratika was right. Divya was right. Lakshita was right. Okay, let's see the answer. Yes, the answer is option number D. Yes, option number 4. Correct. Correct. Everyone is correct. Correct, Ankesh. Correct, Prachi. Either of them can give the evidence in a criminal case. Assertion and reason. The Evidence Act does not apply to affidavits placed to any court or officer. Section 1 of the Evidence Act states that Indian Evidence Act does not apply to affidavits placed to any court or officer. A and R is true and R is the reason for A and R are true and R is not the reason for A. A is true and R is false. R is true but A is false. Come on. Is it given under section 1? Okay. Okay. Is it given under section 1? Anonymous is also saying 1. Is it? The answer number is R is true but A is false. Is it the Evidence Act does not apply to affidavit? Okay, the correct answer is option number 1 here. All of you are correct. And it is given under section 1. Yes, the mentioned answer is wrong. The correct answer is option number 1. Okay, everyone is right here. Let's move ahead. What are the main principles of Indian Evidence Act? Evidence must be confined to matters in issue. Hearsay evidence must not be admitted. The best evidence must be admitted. All of the above. Divya is saying 4. Shubham is saying 4. Pratika is saying 4. Anonymous is saying 4. Okay, yes, the correct answer is 4. Uh, it must be confined to the matters in issue, and hearsay evidence must not be admitted. There are some exceptions to this rule also, and you guys already know about it. We'll have it in the next slides. The best evidence must be admitted. Yes. Which among the following is an example of a conclusive proof? 112, 113A, 113B, Section 5. By the way, nobody answered what are the 5 stages of a criminal proceeding. Which of the following is an example of a conclusive proof? Can somebody tell me what is section 112? It is 112. Can somebody tell me in the comment box? Can a judge or a court exercise his discretion where some kind of presumption is mentioned in the act? Yes, no, maybe, neither of the above. What is birth during marriage? Yes, proof as to legitimacy. Correct. So, can a court or a judge, does a court or a judge has a discretion? Presumption as to legitimacy. Yes. Yes, no, maybe, neither of the above. Okay. So, can a judge disregard the evidence under section 112 and treat is not as a conclusive proof but may treat it as a irrefutable presumption? Apply your mind here, guys. Everyone is saying one. No. If in the act something is stated as may presume, shall presume, or conclusive proof, then there is no discretion of the court or the magistration. Yes, correct, Harsha. No. Correct, Prachi? Okay, Priyanka Bharti said maybe. Okay, no. So the court or the judge, they do not have any discretion because this is an act with the literal interpretation. These presumptions are to be treated as literally, and whenever there is a shall presume or especially the conclusive proof, they cannot treat it as may presume or shall presume. Okay. In which case was it held where the only one eyewitness is fully reliable? There is no difficulty for the court to base conviction on his testimony only. Pandurang Patil versus State of Maharashtra, Kalua versus State of UP, Kusum Ankama Rao versus State of Andhra Pradesh, Anil Fukan versus State of Assam. ये आता है तो आता है, नहीं आता है तो नहीं आता है. Please do not attempt such questions if you have doubts on all the four options. If it is not a landmark thing, please do not attempt such questions. अभी कर सकते हो, but do not do it in your exam, especially DJS aspirants. MP aspirant can still go for it because there is no negative marking. Not still, they have to तुक्का भी मार के आओ तो चलेगा. It is Anil Fukan versus State of Assam, guys. No, it is Anil Fukan versus State of Assam. A is tried for causing grievous hurt to B with a club. Which among the following will be considered as direct evidence? C deposes to the effect that he saw the accused inflicting the blows that caused the grievous hurt. C says that D told him he saw A inflicting blows. C heard a cry far away. None of the above. Direct evidence. Okay. Yes. It is when C deposes to the effect that he saw the accused inflicting the blows that caused the grievous hurt only. Yes. What is 11, Medha? 1 1 means option number 1. Yes, it is option number 1. Is video conferencing included as evidence? Yes, no, maybe none of the above. Divya is saying yes. Pritika is saying yes, yes. Under Section 3 of the Indian Evidence Act, the evidence can be both oral or documentary and electronic. Uh, okay, can somebody tell me through which amendment is this electronic evidence is included in the Indian Evidence Act in the chat box? India, as per Section 3 of the Act, includes whole of the territory excluding Jammu and Kashmir, whole of India except Manipur, whole of India except Nagaland. Yes, it is 2000, 17th October 2000. Yes, come on. Yes, it is whole of India after 2019 Jammu and Kashmir Reorganization Act. The following facts are construed in the case. An hour before the murder, A went to the place of the murder with the child. A alone returned home. Collar of A's shirt found to be blood-stained. The evidence which takes into account the above mentioned fact is called direct evidence, real evidence, circumstantial evidence, secondary evidence. Yes, Harshal, it is 2000. Yes, everyone is right, Prachi and Lakshata. Divya is saying 3, Pratika is saying 3, Shubham is saying 3. Prachi, Lakshata, every one of you are correct. They are circumstantial evidences and not the direct evidence. In which Supreme Court case, the Supreme Court held that relevancy and admissibility are neither coextensive nor interchangeable terms. Their legal incidents are different. All admissible evidence are usually relevant, but all relevant admissible are not admissible. Ram Bihari Yadav versus State of Bihar, Basanti versus State of Himachal Pradesh, Ratan versus Queen, R versus Christie. Okay, let's see. Everyone has one, two, three, a difference of opinion. Only Pritika is right. It is Ram Bihari versus State of Bihar, which kind of differentiated between this relevancy and admissibility. Okay, let's move ahead. What is the object of Section 5 of Indian Evidence Act? It is to aid the investigation made by the courts within the bounds prescribed by general convenience. It is to prevent the investigation made by the court within the bounds prescribed by general convenience. It is to restrict the investigation made by courts within the bounds prescribed by general convenience. None of the above. Yes, correct, Shubham. It was Ram Bihari Yadav. Is everyone saying one, or was it for the previous answer? It is option number 3, guys. Section number 5 is to restrict the investigation made by the courts bound prescribed by general convenience, because in order to restrict the investigation, otherwise, yes, only Divya is correct. It is option number 3. Yes, section 5 is restricting the bounds of the uh, area of investigation. Okay. A is accused of B's murder. Which of the following will not be a relevant fact? A is going to the field with club. A is saying shortly before the incident that he'll take revenge of his father's death. A is fleeing before the police arrived at village. All of the above. Relevant fact nahi hai. A is be accused of B's murder. Which of the fact is not relevant? Okay. थोड़ा सा apply your mind here. It is option number 4, guys. Not 3. Not 3. Yes, all of them are not relevant. Correct, Harshal. You are on fire. See, if you'll read the illustration mentioned under section 5, you'll see that the only relevant fact will be with which weapon A has beaten B, or by what chance A is accused of B's murder. But these facts that A is going to the field with a club, they do not prove to be a relevant fact in proving that A is accused of B's murder. So all of them are not relevant. No Pritika, no Lakshata, only Prachi and Harshal were correct. All of them were not relevant. Okay. In a case of murder by A of B, which facts are relevant? That A immediately left the place of crime before the police reached. That A told his friends about taking revenge of his father's death. That A was seen fleeing with a knife immediately after murder of B. All of them. Yes, it is all of them. It was asked in the DJ's 2007 question. Now, these facts are relevant obviously because since A left the place immediately before the police reached, and A also told his friends about taking the revenge of his father's death, and A was seen fleeing with a knife immediately after the murder of B. These are some facts which are directly in connection with the murder committed by A of B. So that is why all of them were relevant. So these kinds of illustrations you have to apply your mind and then judge the answer. Correct, Lakshita? Correct, Medha? Everyone is correct. Okay. The question is whether A poison B. Applying Section 6 of the Indian Evidence Act, which of the following can be relevant? Marks on the ground produced by a struggle at or near the place where the murder was committed. The stage of B's health before the symptoms ascribed to poison and habits of B known to A, which afforded an opportunity for the administration of poison. The facts that shortly before the poisoning, B went to a fair with money in possession and that he showed it or mentioned the fact that he had it to third persons. None of the above. Under section 6, apply your mind and then answer the question. Okay. Will will option 2, I think, not be relevant under section 8? Facts in the same transaction. Okay. Prachi is saying 4. Shubham is saying 4. Okay. That was for the previous answer. Prachi is saying 4. Okay. It is only Lakshita and Pritika who answered right. It is 2. The state of B's health before the symptoms ascribed to poison and habits, because these are happening under the same transaction, which afforded an opportunity for administration of poison. Because of this line, which afforded an opportunity for the administration of poison, it is coming relevant under section 6. Option number 1 will be relevant under section 7 as effect. Yes, as effect. Option number 3 will be relevant as preparation under section preparation, motive, and conduct. I think section 8. Okay. So that is where you guys get confused. So, yes, option number 2 is the relevant answer here, not 4. Yes, exactly, Shubham. Yes. Continuity and spontaneity in option. That is the reason. See, it is very much visible that it is happening in the same transaction. That is why option number 2 was relevant. Okay, let's move ahead. In which kind of fact Section 6 of Indian Evidence Act admits? It admits only those facts, the admissibility of which comes under the technical expression res geste, that is, the things done, including words spoken in the course of a transaction. But such facts must form part of the different transaction. It admits only those facts, the admissibility of which comes under the technical expression res geste, but such facts must form the part of Benami transactions. It admits only those facts, the admissibility of which comes under the technical expression res geste, but such facts must form the part of the same transaction. None of the above. Yes, if you will know that section 6 का ही मतलब same res geste is also under section 7, 8, 9, 10, not 9, 7, 8, 14. All of these sections are under section 6 only. Yes, it is option number 3. It was very much easy. Facts forming as the part of the same transaction are obviously included under section 6. Okay, again a case law based question, in which case the witnesses had seen only speeding vehicle and not the accident. The injured person explained him the nature of accident. He was allowed to give evidence of what the deceased said because it was a part of res geste. RM Malkani versus State of Maharashtra, Basanti versus State of Himachal Pradesh, R versus Foster, none of them. Okay guys, so कभी कभी फैक्ट्स भी पूछ लेते हैं, सिर्फ हेल्ड नहीं पूछते हैं. Okay, it is R versus Foster, guys. It was a very relevant case in which these were the facts जहाँ accident होता है, or it was held that the witness had seen only the speeding vehicle and not the accident. The injured person explained him the nature of accident. He was allowed to give evidence of what the deceased said. जो deceased ने बोला वो evidence देने के लिए, because it was a part of the same transaction. A girl named Lalita was raped. The culprit have gone away, and after coming from the scene of occurrence, she made a statement to her mother. Does her statement will be admissible under section 6 of the as the part of same transaction? Yes, it will be admissible. No, it will not be admissible. It will be partially admissible. None of the above. Correct, Shubham. You are on fire. R versus Foster it is. Harshal was also correct. Priyanka was also correct. Meghna was also correct. Okay, Pritika and Medha are saying it is a part of the same transaction. ये same transaction हो रहा है. Shubham is also saying one. ये same transaction हो रहा है क्या? It will not be admissible. इसीलिए यहाँ पे you guys make mistakes. It was held under Gulam versus R. Yes, Anonymous is right. Anonymous, please tell us your name. I am really surprised that only one person is right. Divya is also right. Yes, it is not visible, not admissible, guys. उसका reason ये है कि this is not a part of the same transaction. वो चली गई, फिर आई, फिर उसने अपनी मम्मी को बताया कि उसका रेप हुआ था. तो इस कंडीशन में उसका स्टेटमेंट पार्ट ऑफ द सेम ट्रांजेक्शन कैसे हुआ? देयर शुड नॉट बी गैप्स, राइट? यही पढ़ा था ना सेक्शन 6 में. गैप नहीं होने चाहिए. Yes. Okay. Yeah, section 6 is all about it is all about time. So always remember this. Part of the same transaction. Karan was murdered in one of the crowded bazaars of the Bhopal. At trial, Miss Gandhi was examined as witness. She stated that when she reached at the spot, she heard the people present saying that Sambha, Gabbar, and Jagira had killed him. Whether her statement will be admissible in the court under section 6? No, it will not be admissible. Yes, it will be admissible. It will be partially admissible. None of the above. Yes, exactly, Lakshita. Medha is saying no. Hi, welcome, Harshay. Harshay is saying no. Priyanka is saying no. Prachi is saying no. And the answer is no. Yes. Uh, it was nowhere stated that people who informed her the names of the culprit were present when the murder was being committed. So part of the same transaction under SGST presence is necessary. अगर देखा नहीं ऐसी सांबा गब्बर जगीरा चिल्ला रही थी, so there is no point of considering under section 6. Which of the following statements is true? A is tried for the murder of B. There is evidence of the fact that B prosecuted A for libel and that A was convicted and sentenced. The judgment is conclusive proof of the murder of B by A as it is judgment in rem. Relevant but not conclusive proof as it relates to matters of a public nature relevant to the injury. Relevant as the existence of such judgment is a fact and issue. Relevant under section 8 as showing the motive of the murder of B. Yes, this was a case of continuity. अच्छा वो अभी गब्बर जगीरा वाले में नहीं. Gabbar Jagira wala case was not Samba Gabbar and Jagira was not the case of continuity. Yes, the time gap was not there, but वहाँ पे तो मतलब she shouted it ऐसे ही गब्बर जगीरा. मैं भी कुछ भी बोलने लगूंगी, so that cannot be. Who told her the names of the culprit? Did she see the murder? ठीक है. ठीक है, it is relevant. Correct answer is option number 4, relevant under section 8 as showing the motive for murder of B. Yes, it shows motive for the murder of B. It is correct. Everyone was able to answer correctly. The question is whether A robbed B. The fact that after B was robbed, C said in presence of A, the police are coming to look for the man who robbed B, and that immediately afterwards A ran away, are relevant as motive, intention, previous conduct, subsequent conduct. It is relevant as a subsequent conduct. Correct. It was an illustration F of section 8. Where the eyewitness cannot give the name of the offender but claims that he can identify him. Will test identification parade be held in this case? Yes, no, depends on facts, court shall decide. Yes, it is a subsequent conduct. Everyone was right here. Yes, it is option number one. It was a case Lakhminder Singh versus State of Punjab, where the eyewitness cannot give the name of the offender but claims that he can identify him. Obviously, identification parade can be conducted in this case, though the person should not be known before. Obviously, and if the person cannot give the names and he ensures that he can identify him, obviously section 9 comes into the picture. A accused of theft is seen to give the stolen property to B, who is seen to give it to A's wife. B says as he delivers it, A says you are to hide this. B statement is relevant as explanatory, introductory, supportive, or rebuttal. Yes, it is relevant to section 54A also. It's very good that you can interrelate. Only Prachi is saying 3, rest of you are saying A. Yes, it is an illustration under section 9. Clause E, it is explanatory. Obviously, it explains that A is only the person who has committed the theft, because A says you are to hide this. Your husband is saying you have to hide this. So obviously, this is explaining the nature of the offense under section 9. In charge of murder of A, where the prosecution case is that on the day of incident, the accused uttered a threat that he would finish off A and then also kill himself. Is this evidence admissible to show that the accused, after killing A, tried to kill himself? Yes, no, maybe, can't say anything. Come on, guys. Shaktija, welcome to the session. Everyone is saying one. Yes, it is option number one. A is charged with shooting at B with intent to kill him. In order to show A's intent, the fact of A's having previously shot at B may be proved under which of the following: section 14, 8, 10, 15. Come on, guys. This has to be correct. Come on, everyone. This has to be correct. No, it is option number 14. It is option number 1, section 14, and it is an illustration under illustration I of section 14. Is it section number 8? Can someone confirm? Let me also check my Bear Act. You and I also think is it as a previous conduct. Yes, it is section 14, state of mind or bodily feeling. It can be relevant under section 8 also as a previous conduct, but it is an illustration given under section 14. इसलिए DJs के लिए illustrations begin very important. Yes, it is an illustration I under section 14. That is what, see, it is a previous conduct also. These sections are relevant altogether. 6, 10, 9, ये सब के सब जो sections हैं, They are interconnected in a way. But the thing is कि ये most appropriate answer is section 14 here, because it is an illustration given there and it shows the state of a mind or the bodily feeling. It shows the state of a mind and not the bodily feeling, but it shows the state of mind. Okay. Yes, it is under section 14. And the correct answer is option number 1. A is charged with the murder of B by drowning if he states that I and B were bathing in the river. C came and began to drown B. I tried to save B but could not. This statement is admission, confession, court shall decide, depends upon the parties. I and B were bathing in the river. C came and began to drown B. I tried to save B but could not. Yes, it is an admission. Admissions can be in the favor also. Yes, it can be in the favor also. It is an admission. Yes. Preeti was charged with having committed murder of Natasha on the night of 10th July 2022. He stated that the deceased Natasha caused injury on her toe at about midnight on 10 July 2022 by biting him. This will amount to confession, either confession or admission. Admissions, neither admissions nor confessions. Come on, guys. घूम गए क्या? This is also admission. uh, it is not amounting to conviction. Obviously it is not expressing, the person is not expressing the guilt, so that is why confession nahi hoga, it is admission. Yes, everyone is right, it is admission. Is the bar under section 162 applicable to the court's power to ask question under section 165 of Indian Evidence Act also? Yes, it is applicable. No, it is not applicable. Can't say, none of the above.
हाँ हाँ बोल दिया उसको पहचान तो ऐसे नहीं पा रहा है कि मैंने बोल दिया अपनी तरफ से भी तो बोला बात करता हूँ राहुल से हाँ बोला मैंने
Okay.
हाँ लेकिन बहुत ज्यादा उसके भरोसे न रहना
The correct answer is option number 2. It's not applicable because 162 was CRPC's provision. It imposes a ban on the use of statements of witnesses recorded during police investigation. But under Section 165, a court has the right to use the statement made by the witnesses during the investigation. The restriction imposed under Section 162 cannot limit the power of courts under Section 165. That is obvious. Yes, Shubham is right. It is not applicable. 162 alag hai and it restricts the power of the uh, court because of some other reason, and 165 may there's no restriction. The question is whether A assaulted B. C deposes that he heard A say to D, B wrote a letter accusing me of theft and I will be revenged on him. The statement is relevant as showing A's motive for the assault and evidence may be given of it, though no other evidence is given about the letter. Irrelevant as it does not show A's motive for the assault and evidence may not be given of it, though other evidence is given about the letter. Conclusive proof as showing A's motive for the assault and evidence may be given of it, though no other evidence is given about the letter, either 1 or 3. Come on. Is it? Yes, it is an illustration under section 144, guys. Direct illustration taken from that act. It is option number one. It was relevant because it showed A's motive for the assault, and letter के लिए कोई भी evidence नहीं दिया था, but A का motive clearly show हो रहा था. That is the reason it was relevant. No, three is not. It is not a conclusive proof. थ्री तो हो ही नहीं सकता. It is not a conclusive proof. Okay. The privilege to examine witnesses has been extended to jury by the leave of judges, assessors by the leave of judges, only judge, both one and two. Come on, guys, ये बहुत easy question है. This is the easiest, I think, अभी तक. Apart from the first few questions, this is the easiest. अभी बहुत heavy हो गया because we had a lot of illustrations. It is option number 4, both 1 and 2. It is mentioned under section 166. Both 1 and 2 have the right to, examine, get the witnesses examined. Yes, Pritika is right, Prachi is right. Okay. If witness has been previously convicted of a crime and he denies it, can be given of his previous conviction? Yes, no, no, yes, only with the permission of the witness, maybe. Correct, Shubham. Correct, Kriti. Correct. Okay. Yes, it is option number 2, and it is an exception to section 153. Evidence is allowed because of not 153 but only 53. This is only section 53. The evidence is allowed of the previous conduct only in the criminal cases. Yes. So is it section 153? 53 is the section where the character evidences is given. Yes, it is section 153 where the exception is provided. Yes. Okay, whenever any statement relevant under section 32 or 33 is proved, all matters may be proved either in order to contradict it, corroborate it, impeach the credit of the person by whom it was made, either of the above. It is 53. Yes, not 153. It is 53. Whether any statement relevant under 32 or 33, that is the dying declaration, is proved, all matters may be proved either in order to contradict it, corroborate it. ये exception is given under 153 where the evidence can be given, okay, but the character evidence section is 53. Yes, it is option number 4, and it is mentioned under section 158 very clearly that you can contradict it, corroborate it, or impeach the credit of the person by whom it was made under 32 or 33. तो ऐसा नहीं है कि 32 और 33 में जो भी बोला वो सच मान लेते हैं. इट वॉज एन इम्प्रेशन कि डाइंग डिक्लेरेशन में जो भी बोला, मरता हुआ आदमी सच बोलता है, ऐसा है, बट मतलब द कोर्ट कंसिडर्स इट, द इंडियन लॉ कंसिडर्स इट कि मरता हुआ आदमी हमेशा सच बोल के जाएगा, बट you have to, the courts can contradict it, corroborate it, or impeach the credit of the person by whom it was made under section 158 of the Indian Evidence Act. Okay, if a witness wants to refresh his memory through a writing, then is it necessary that the writing should be admissible? Yes, no, maybe court shall decide. Come on, guys, very easy. I also need in the comment box which is the relevant section for refreshing the memory under the Indian Evidence Act, which is the relevant section. Okay, okay. Kritika and Shaktija are saying yes, it is not necessary the writing should be admissible in evidence. Admissible ho ya na ho, refresh karani hai memory. FIRs are not sometimes. It is 159. Sometimes the documents are not admissible as evidence, are not substantive evidence, but memory refresh करवाई जा सकती है. Okay. Which is, I think the questions are really giving you some things to learn, right? Are we on the same page, guys? I'll ask this question after we are halfway through. Abhi to nahi. Let's continue now. Which is the most appropriate definition in relation to a hostile witness? A hostile witness is the one who, from the manner in which he denies the evidence, shows that he is not desirous of telling the truth to the court, is one called by a party to prove of a particular fact, who fails to prove such fact or proves an opposite fact, is a witness who explained over by opposite party, is one who is produced out of the fear that he might disfavor the party who has produced it. Yes, it is very easy. Bhari hai question, bada hai question, but it is very easy. Yes, it is option number two. Hostile, it was a question from DJs 2010. So hostile witnesses are those जो पलट जाते हैं अपनी बात से in the witness box when they deny their own said thing, they become hostile. Can somebody tell me the relevant section? Come on. A party can ask question to his own witness under which section of the Indian Evidence Act? 156, 154, 158, 160. Hostile witness का section बताओ पहले फिर ये आंसर करना. Yes, it is 154. Yes, it is 154. Where to get the access of this PPT? Are you an enrolled student with us, Harshi? Yes. It is 154. A gives B a receipt for money paid by B to A. Oral evidence is offered for the payment. What is the status of evidence under Section 91 of the Indian Evidence Act? It is admissible, not admissible, irrelevant. It is secondary evidence. Come on. It is admissible and it is an illustration under Section 91D. And whenever the receipt for money is paid and oral evidence is offered, obviously it is relevant under Section 91. Yes, correct. Lakshata, correct. Shaktija, correct. Harshay, then please contact you can write it on the group and then we'll figure it out, the PPTs. A policy of insurance is affected on goods in ships from Calcutta to London. The goods are shipped in a particular ship which has been lost. The fact that particular ship was orally accepted from the policy can be proved, cannot be proved, can be partially proved, none of the above. Yes, it not being a term of contract. The previous one, right? It cannot be proved and it is under section 92 illustration A, it is exempted. Yes. The oral evidences are accepted. Yes, correct Shubham, correct Lakshata, correct Priyanka. Put out the incorrect statement. No leading questions may be asked in examination in chief without the permission of the court. Leading questions may be asked in cross examination with the permission of the court. No new matter should be introduced in re examination without the permission of the court. None of the above is correct. Incorrect. क्रॉस एग्जामिनेशन री एग्जामिनेशन एग्जामिनेशन इन चीफ ये लगते बहुत इजी हैं जब इलिस्ट्रेशंस आती हैं तो वी गेट कंफ्यूज्ड it is option number 3 new matter should be introduced in the re-examination obviously re-examination ka purpose hi yahi hai cross examination mein cannot be a no Priyanka leading questions can be asked in the cross examination with the permission of the court but may be asked and no new matter should be introduced new matter can be introduced even without the permission of the court in the re-examination everybody was wrong re-examination wala tha only Shubham was right. Okay. A desires a court to give judgment that B shall be punished for a crime which A says B has committed. A must prove that B has committed the crime. A must prove that he has not committed the crime. A and B both can prove none of the above. Who has the burden of proof? Yes, it is A who has the burden of proof, who asserts the fact, जिसने बोला उसके ऊपर ही burden होगा, so A has the burden of proof in a criminal case. Correct. It is also under illustration A. Section 111 of Indian Evidence Act speaks of such situations where one person stands in a position of dash to the other person. Active faith, active confidence, confidence. This is truly a section based question. Come on, guys, I'm just giving you 5 seconds to this question. For this question, only 5 seconds are allotted. Yes, it is active confidence, and it was a truly section based question. Mark the incorrect statement. A conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice, not accomplish, but accomplice. An accomplice is unworthy of credit unless he is corroborated in material particulars. It is not illegal to act on an uncorroborated evidence of an accomplice, but it is a rule of prudence that it is unsafe to act on such evidence unless it is corroborated in material respects. The evidence of one accomplice can be used to corroborate the testimony of the other accomplice. Accomplice का एक बार section बता दो सब comment box पे, and then answer this question. Mm. Correct. Everyone is correct. Option number 4 here. एक accomplice का the accomplice one accomplice evidence cannot be corroborated for the other accomplice. Corroboration has to be done independently, obviously. Can somebody tell me the section? Yes, it is 133. Assertion and reason. Again, an accomplice shall be a competent witness against the accused person. An accomplice is unworthy of credit unless he is corroborated in material particulars. Both A and R are individually true, and R is correct explanation of A. Both A and R are true, but R is not the correct explanation of A. A is true, but R is false. A is false, but R is true. It is 1. R is the correct explanation of A, guys. जहाँ पे भी ये question आता है assertion and reason में, obviously I was also like very poor in solving the assertion and reason question, but अब मुझे like slowly and gradually I've understood the trick to crack it. You just need to apply your mind. अगर दोनों statements correct हैं, then it's the most difficult thing. ये जज करना कि whether R is the correct explanation of A or not. R is the correct explanation of A. He will be competent against the accused person, but he has to be corroborated in material particulars. Because the meaning of the accomplice is such, because जो वो मतलब he did not rely to the person who he came with, तो अब how can he be like trusted? That is why that this is the logic I applied, and that is why A is the correct explanation of R is the correct explanation of A. All the persons are competent to testify unless the court considers that they are prevented from understanding the questions put to them because of tender years, extreme old age, mental disease, all of these. Who all are competent to testify? Competent witnesses. Yes, section 118, who may testify, all of them can testify. It was a question in 2014 DJs. Yes, correct. The changes in section 119 has been made by which of the following? It is made in 2013, that is clear now. Which act has made the changes? 10 of 13, 2013, 11 of 2013, 12 of 2013, 13 of 2013. जिसने बेयर एक्ट को एकदम घुस के पढ़ा होगा सिर्फ वही आंसर कर सकता है. These questions are relevant in Himachal. These kind of questions where act number is asked. Let's see. It is option number four. Very good, Shubham. Divya, very good. You have घोट लिया तुम लोगों ने Bear Act. Yes, it is option number four, Act number 13 of 2013. Correct. A asked B's leave to take some vegetables from his garden. Having received the key fraudulently, he took the possession of the garden and refused to vacate. In suit for ejectment by B, A can't say to B, A had no title. Okay, this is a wrong question. The principle of estoppel is based on which of the following cases? Picard versus Sears, Kunti Devi versus Radhesham, Sharda Chandra De versus Gopal Chandra Laha, none of the above. This is the most landmark case you guys can ever know. That question had a defect. I had to delete it, but वो सारी slides में अभी भी आ गया है. Yes, it is Picasso versus Sears. Picasso versus Sears is one of the landmark cases of doctrine of estoppel under Section 115 of the Indian Evidence Act. Yes, okay. Which of the following facts need not be proved? Oral evidence, documentary evidence, facts taken judicial notice by court, relevant facts. Yes, it is facts taken up judicial notice by court under section 57 it is, and daily APP 2008. It cannot be proved, and जो judicial notice की list है it is 57 under 57. It was a question in 2008 Delhi assistant public prosecutor exam. Section 58 completely bars the court from proving the admission by the parties. Yes, no, maybe, can't be said. Come on. Section 56 है, the list of judicial notices are under section 57. It is a provision to section 58. It does not completely bar from proving the admission by the parties. Court can prove the admission by the parties under section 58. Yes, Shaktija was only right. If oral evidence refers to the existence or condition of any material thing other than a document, the court may, if it thinks fit, require the production of such material things for his inspection. Yes, no, maybe, court shall decide. It's discretionary power. Come on. Yes, it is a provision to section 6. The court, if required the production of such material thing for its inspection, and oral evidence refers to the existence of the condition uh, of any material thing other than a document, the court can do so for the inspection purposes. Yes, it is a provision of section 60. Can someone tell me which provision? What is the nature of a statement given in a narco test? It is not an evidence, it is a scientific evidence, it is an oral evidence, it is a circumstantial evidence. Narco test का evidence का nature क्या है? Somebody is saying it is a scientific evidence. Guys, it is an oral evidence क्योंकि वो बोल के दिया जाता है. It is not a scientific evidence. It is an oral evidence. It is an oral evidence, guys. It is an oral evidence. सब अलग अलग. It is an oral evidence. The presumption under section 80 of the act is irrefutable, irrelevant, rebutable, relevant. It is an evidence. Narcotics test is admissible. हाँ वो सेल्वी versus state of Karnataka को याद करके बोल रहे हो, but that is without the permission or without the consent of the person. It is a relevant evidence. Yes, it is a reputable evidence under Section 80. Which of the following is an example of may presume? Presumption as to electronic records, presumption as to digital signature certificate, presumption as to electronic messages, presumption as to electronic agreements. May presume. Let's see. It is option number 3. Everything else is a shall presume. Otherwise, only presumption as to electronic messages is only a may presume. Section. The documents furnished to the Press Council of India for its recommendation are not a public document because they are open to public inspection, private document, neither private nor public document. Press Council of India for its recommendation. Let's understand. It is a public document and it was held in Indian Federation of Small and Medium Newspaper versus Press Council of India. It is a public document. Guys, यहाँ से दो options तो अपने आप ही eliminate कर दिया करो. Use elimination method in such questions. Not a public document and private document are meaning the same thing. So first और third तो वैसे ही eliminate हो गए. नहीं भी आता था तो भी बन जाता. Yes, it is a public document. Yeah, because obviously because they are open to public inspection. What was the objective behind section 77 of the act? To avoid wear and tear of public documents, to not to deprive others of the document while a case is pending in court and the document is required there. Access to the document while a case is pending in the court and document is required there, to avoid the risk of the loss, all of the above. Okay, Divya is saying 4. Yes, it is 4 for the purpose of all the things mentioned here. Section 77 is designed. Correct. Everyone is correct. When a number of documents are made by one uniform process, as in the case of printing, lithography, or photography, each is secondary evidence of the contents of the rest, primary evidence of the contents of the rest, direct evidence of the contents of the rest, documentary evidence of the contents of the rest. Direct or bare question. Let's see. It is a primary evidence of the contents of the rest. No, it is the primary evidence of the contents of the rest. It is section 62. Yes, Pritika is right. Anonymous is right. Where there was no possibility of the documents being compared with the originals, as the originals with another person, the document could not be accepted as secondary evidence, in which case the Supreme Court held this. Manik Lal versus Hormasji, J. Yashoda versus K. Shobha Rani, Zarina Siddiqui versus A. Ramalingam, Nawab Singh versus Inderjeet Kaur. It is J. Yashoda versus Shobha Rani. Guys, ये questions attempt मत करके आना other than Pritika Anonymous. Please do not attempt these questions whenever there is a case law based question and you have no idea about it. Is there any particular form to be employed in making a dying declaration? Yes, no, maybe, can't be decided. कोई particular format चाहिए DD के लिए under section 32? Yes, it is a very basic question. No particular form. Dying मरता हुआ आदमी कभी झूठ नहीं बोलता. This is the only principle on which dying declaration is based. Dying declaration may be oral, written, partially written, all of the above. It is all of the above. Yes. A rustic woman in apprehension of assault and maltreatment takes a confession of murder of a mother-in-law at the village panchayat. Whether this confession is admissible as extrajudicial confession, inadmissible due to involuntariness, as a supporting evidence to the fact deposed by the other witness, partially admissible.
हाँ हाँ
Okay, there was a technical glitch. Yes, it is option number two. It admissible because voluntary nahi tha ye admission. That was under the pressure, or you can say in front of in front of the person itself. So yes, it was not the admissible evidence. Okay, which of the following is true concerning retracted confession? It is the law that one should presume that it was trained and be thrown overboard. The retracted confession of the accused person is very weak, and if retracted, the same is admissible against the maker of it. The court is bound to make the factum of retraction of confession. Retracted confession must be looked upon with lesser concern. It is option number three, guys. The court is bound to take the fact of retraction of confession. A retracted confession is a confession voluntarily made by a person and subsequently retracted. State of Rajasthan and the Supreme Court held that a retracted form of confession can form the basis of conviction if and only if the court is satisfied that it was true and made voluntarily. Yes, Lakshita is right. Okay. A document claimed to be a will shall not be used as evidence until all attesting witnesses have called for the purpose of proving its execution. All attesting witnesses alive and subject to the process of the court and kept capable of giving evidence have been called for the purpose of proving its execution. One attesting witness at least has been called for the purpose of proving its execution if there be an attesting witness alive and subject to the process of the court and capable of giving evidence. It has been registered in according to the provisions of the Indian Registration Act. Yes, it is one attesting witness which is required under section 68 of the Indian Evidence Act. Correct. Okay. An attested document not required by law to be attested has to be necessarily proved by examining an attesting witness, may be proved as it was unattested, is inadmissible in evidence, can only be proved by examining the executant. Okay. May be proved as it was unattested and it is mentioned under section 72 very clearly. Let's move ahead. Are we on the same page, guys? We are halfway through kab se, but I did not ask it. Are we on the same page, guys? Yet it is a previous year question. Are we on the same page? Is everyone with me? Let's move ahead with a few last questions. Okay. For leading secondary evidence, moving an application seeking permission thereof immediately after admission or denial of documents and before framing of issues is essential. An application seeking permission of the court is to be filed before the commencement of evidence of the party seeking to lead secondary evidence. No application seeking permission of the court is necessary. An application seeking permission, if not filed earlier, can be filed even after conclusion of the evidence. For leading secondary evidence. It is option number three, guys, and not two. No application seeking the permission of the court is necessary, and it is mentioned under section 65. घुमाने के लिए question था ये. In a suit to which the bank is not a party, the contents of the book of a bank can be proved. Shubham was saying for no. by compelling an officer of the bank to produce the said books, by tendering the evidence in evidence a copy of the said contents certified by the bank in terms of section 2A, 2A and 4 of the Bankers Book Evidence Act without compelling the presence as a witness of the officer of the bank, by compelling the presence of the person in charge of the computer system of the bank to prove certified copies of the printouts of the data stored on the said computer system, by examining the principal accountant or branch manager of the bank. It is option number 2, and it is mentioned under section 61, guys. No one, it is 2. Yes, correct, Shubham, correct, Lakshata, everyone is correct. The court has issued a commission for recording of the evidence in a suit by appointing a local commissioner. The counsel for the plaintiff raises objections to certain questions put by the counsel for the defendant to the witnesses of the plaintiff in cross examination. The commissioner is necessarily required to stall further recording of evidence and refer to said objections to the court for decision thereof, is empowered to decide the said objections and proceed with recordings of evidence, is empowered to decide the objections only if there is no bar in the order of the court issuing the commission to the commissioner deciding the said objection, is required to record the said objection and ask the witness to answer the question so objected to without prejudice to the plaintiff's right to have the said objection decided from the court at the time of final arguments in the suit. I think there is some issue again. Is my screen visible? Everyone is saying 4. Is my screen visible, guys? I think no. No, yeah. Okay, everyone is saying 4, and the answer is 4. Okay, this was a question from CPC, but everyone was able to answer, and it can be related to Indian Evidence Act as well because issuing of the commission to record the evidence. Okay, let's move ahead then. Putting an exhibit mark on document disentitles either party to the suit from contending that the document is not to be read into evidence. Disentitles either party from contending that at the stage of final arguments that the document should not be read to into evidence unless such party had at the time of putting of exhibit mark raised objection to its admission into evidence and such objection was kept open for decision, does not ipso facto amounts to admission of the document in evidence, especially if the document is per se not admissible into court, is final as far as the suit court is concerned of admission of the document into evidence. Putting an exhibit mark on the document. It is option number 3, guys. It does not ipso facto amount to admission of the document in the evidence, especially if the document is per se not admissible into evidence. Yes, correct. Lakshata is correct. The court may presume that when a document creating an obligation is in the hands of the obligator, the obligation has been discharged, that an accomplice is unworthy of credit unless he is corroborated in material particulars, that judicial and official acts have been regularly performed, and that a bill of exchange accepted or endorsed was accepted or endorsed for good consideration, and that a judicial and official acts have been regularly performed, and that the common course of business have been followed in particular cases, and that evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it, and that if a man refuses to answer a question which he is not compelled to answer by law, the answer, if given, would be unfavorable to him. All of the above. May presume. Correct. This was very heavy, but it is the illustrations are directly taken from section 114. Yes. The fact that any person was born during the continuance of a valid marriage between his mother and any man is conclusive proof that he is the legitimate child of the man of that man, is the conclusive proof that he is the legitimate child of that man, unless it can be shown that the parties of the marriage had no access to each other at any time when the child could have been begotten, is no proof that the child is the legitimate child of the man, is no proof of legitimacy unless proved by other evidence. Correct. It is directly taken from 112. Estoppel is an equitable principle, is a rule of common law, is a principle evolved by judicial pronouncements, is codified in Indian law. Correct. Everyone was correct. Estoppel. Yes, it is an equitable principle. Everyone is correct here. A party to a suit can prove a fact in issue by examining one witness only in proof thereof, by examining not more than three witnesses in proof thereof, by examining any number of witnesses in the proof thereof, unless the court is satisfied that the examination of the particular witness is not relevant and is with the intent to delay the trial, by examining any number of witnesses in proof thereof, and the court cannot limit the number of witnesses sought to be examined. There is the same issue again, I guess. My screen has stopped working again. It is equitable. Yes, everyone was is right, but I'm not able to share the screen. Okay, someone was there. Yes, now I think it is visible. Let's move ahead with the last question, I think, because I checked the slide. During continuance of possession of immovable property, in the possession of is if the possession is stopped from denying the title to such immovable property of the person who put him in such possession, if the possession is tenant, the possessor is a tenant, the possessor is a licensee, the person in possession is an authorized occupant, both one and two, unauthorized occupant. Everyone, Priyanka is right. It is mentioned under section 116 of the Indian Evidence Act. So that was the last question, guys. I'm sorry for the technical glitch. I think my screen was stopping from getting shared through the software again and again. I don't know why. Okay, Divya. It is an equitable principle, I think, under section 115. Let's check it again and meet again in the next quiz and we can discuss over it. What about the quiz, guys? How were the questions? The level of the questions? Please clear. I think it is an equitable principle. This is what I think, and it was not codified in India because Section 100 and estoppel is not the Indian law. It was evolved by the case of Picard versus Sears, which was not an Indian case. This is what I think. We'll have to check. It is an equitable principle. Yes, it is an equitable remedy. I've checked it on the net. Promissory estoppel is an equitable defense. Yes, it is an equitable recourse. Thank you, everyone. Thanks a lot. Thank you, Shubham. Thank you, Pratika. Divya, I think it's clear now. Okay. Let's meet again in the next quiz. And I think the preparation is going fine and smooth. Please be very careful with the mistakes you all have committed. Revise the mistakes and let me know. Okay?